Testing 1, 2, 3. Sounds like you hear me anyway. All right. Welcome to Legal Issues and Privacy Laws. I'm your moderator, Randall Shepard. I'm a comrade for some number of years. I'm also a lawyer. It's probably what got me tabbed to be on this. There are other lawyers on the panel, but we'll start with introductions with Sean.
I'm Sean. I'm a lawyer.
Hi, Sean. No.
How many years have you been in recovery?
I've been an attorney for about 25 years, almost 25 years. Most of that time I've worked for the government. I'm a criminal prosecutor.
Cool.
I am not a lawyer, but I've had to deal with privacy issues working with the program on the Dublin Worldcon.
Okay, Bruce Farr, a CPA, not a lawyer. Never have been, never will be. And I dealt with privacy issues for decades, including, of course, with GDPR with Dublin.
Hi, Cathy Green. I'm also a lawyer. Been practicing for 20 plus years. Not really practicing now, but in a previous job for a government agency, I was dealing with information and privacy. So I do have some ideas on the privacy law end, and just sort of in general, when you go to law school, they tell you that, they train you to think like a lawyer. Unfortunately, they don't then tell you also that then you can never, ever turn it off, which, so it's mainly about issue spotting. So to some degree, from my perspective, what I hope the panel will do is sort of raise issues. We won't necessarily have the solutions because those will often be very local. But that's my hope for the panel, is to raise issues that you need to consider. And in terms of the Spanish end of things, I've been very active running CapClave for a number of years, and I'm part of the DISCON 3 committee.
And Bruce, who, although I'm going to note, even though you're a CPA, your years in convention, you dealt with a significant number of contracts. So you, like Bobby and Patty and Ben, and some of these people done a lot of contract work, or at least somewhat lawyer-like at the contract basis anyway. The disclaimer is, even though there's several lawyers up here, that none of us are giving you any legal advice. This is, as Cathy said, issue spotting, that you may then go talk to lawyers from your state that can give you proper advice. So off we go.
Never trust a lawyer.
Yeah. Well, Shakespeare said, "Kill all the lawyers," but that line is, they were trying a revolution and then they had to get the lawyers out of the way. It's actually not the earliest lawyer joke told, but we are a good thing at time to time. All right. Off the top, contracts are something that comes up a lot for conventions, so we'll start with that before we get to privacy. What's your, how many of you have been involved in conventions and been an actual legal advisor, and how many of them are just, well, so-and-so's a lawyer, he's on the committee, he'll just get them to look at it? Anyone?
Well, certainly I did not practice transactional law. So from my perspective, if I'm looking at a contract, I'm less doing it as a lawyer and more looking at it to see, are there red flags that I see where, the liability shifted in a way I don't think it should be there. I certainly think for a smaller convention, if you have someone who's done a lot of hotel contracts, or who's, done event planning and knows those contracts, they can look at it and say, that's not a standard clause, that's weird. And, if you're renewing a contract, you don't have to be a lawyer to be able to do the sitting down and looking at the contract side by side and making sure it didn't change. And if it did change, why did it change? And being, and don't be afraid to push back. These are a negotiation. These are, some parts will be fixed, other parts won't. For something like a Worldcon, where contracts may be more complicated, you probably do want to, there's a reason why Worldcons will actually hire law firms, because there are multiple legal issues across multiple jurisdictions nowadays, even international. And that's not something you necessarily want to just wing it yourself. In other contexts, you may need someone with specific where you can maybe use a canned contract. I mean, for in the context of the Washington Science Fiction Association and CapClave, we sometimes do books, sign limited editions with our guests of honor. And we have a canned agreement that we got from friends in the industry where it's been tweaked to meet our needs, and we get pushback from the author's agent. But, you know, we don't need to be lawyers to do that. We're working with an already essentially established industry document.
Bruce.
I wanted to give a bit of a war story, just showing the amount of leverage between getting good advice, including legal advice, and not getting it and the impact it has. There was a Worldcon a few years ago where the hotel contract was fairly good, but left some holes in it. And in trying to fill those holes, to patch it, it cost over 1,000 extra hours of work and about 5-6 months of negotiation with the hotel. So when you are doing legal issues, when that's something you've got to focus on, it's good to bring in some horsepower at the beginning, getting people to review contracts, to review your privacy policies, everything having to do with the lawyer. Do it as early as you can at the front end, so you're not then having to go and backfill.
John or Ian, you got anything you want to add to that? Or?
Not at the moment.
Okay, no, let's see. There's not a right or wrong question. All right. So what do you do when you've got on the committee with, oh, Kent?
Can you speak to other contracts? Because the hotel contract, especially for the World Cup, is not the only contract you sign. You have banking relationships and supplier relationships.
Lots of supplier relationships. We're ordering in tech, we're ordering in decorator.
And ordering something off the web establishes a contractual relationship that sometimes can go south. Just comment, repeat the question, or if you have questions, you can step up to the mic or grab the mic so people online.
I'm happy to repeat the question for folks. All right. So what do you do when the committee's not having the lawyer look over things and they're signing contracts, and then you find the oop, we thought it was the same as last year? Anybody running into experiences where
I'll go ahead and
butt
do that.
heads? Okay.
Yeah. Again, usually it costs time and resources to close up that particular gap. The number one thing, according to what Kent is talking about, let's say with tech contracts, the important thing there is to, of course, bring in people who have experience with that area, as well as the people who have the signing authority, so that they can get all of their issues addressed at the front end, as well as the people who have, say, budgetary authority, say treasurer. The rule that I've always gone by when I've done treasury or budget work is you want to always make sure you have the chair at least represented, not just by delegate, but say an advisor or someone else who has some amount of chair authority, as well as someone from the budget area or finance area, so that they can speak to the impact of the overall convention. Plus, of course, the department that's going to be doing the contract. And lastly, hammer on the fact that you do not have a valid contract without the chair agreeing to it, without them signing the bottom line. No one else can bind the convention, period.
But Kent's shaking his head, as in.
Can I assume you also meant a lot of the other third-party relationships?
But you delegate authority to make contracts. At least I did when I was chairman. And I only had to sign the ones that were over a certain level, where they were either too critical or too costly for someone with less authority. But my division heads had the authority to sign contracts in some circumstances. And it's up to the corporation and the corporate structure who gets to sign contracts. The one thing you can't do is you can't sign contracts for the World Science Fiction Society. In spite of what several people have attempted to do, you must do it in your own name and not in the name of the society.
I mean, absolutely. At least in the U.S. context, the conventions, typically there's a 501c3 corporation. You will want to have all of your corporate documents in order. As Bruce said, you want to make it very clear who has the signing authority and at what levels, because it may be that someone does overstep, and you want to have the ability to say, no, you knew because we had our bylaws or whatever posted, these are the people with authority. You know, that this is not a binding contract, but at the same time, of course, to certain levels, you want to delegate it because you don't want things to grind to a halt. The flip side being, while a WorldCon is big, there may be areas where, as Kent indicated, a lot of the time you are effectively entering into a contractually binding relationship, shrink wrap licenses, things like that, where you're buying product off the shelf. You may not have the ability to negotiate at all. That's a thing. We are not such a big enterprise that we can go to PayPal and say, I need these extra clauses added, or you have to do this, Square, you have to do that. In some cases, you may actually have the ability to do those negotiations because presumably whoever you enter into copying and printing services with, you should be able to negotiate a really good rate because you will be giving them a big order. For other things, no, there are going to be existing laws. You're going to be dealing with large corporations, and they're the ones that are going to be having the power. Or it's as I said, a standard shrink wrap license, and there isn't a lot you can do about that.
Mr. Yalla from New York will be recognized.
Thank you. Particularly with things such as facilities contracts. For convention centers, you almost always have no latitude whatsoever on signing the contract in many cases. Certainly in many locations, you're dealing with a municipal entity, and unless you can get the city council or the state association for convention centers or something like that to agree to amend the contract, then essentially it's the equivalent of a shrink wrap license. You're going to sign it or you're not going to go there. Now, you can then try and get informal agreements, but the formal agreement is one that you're stuck with. There is also the fact that even if you're dealing with a hotel contract or something like that, where you can negotiate, certainly it's not going to be, the chairman will probably have to sign the original contract, but you are probably going to send in someplace between a dozen or several dozen contract amendments. You're not going to bother the chairman for all of those. Your baseline contract will say that these people have the authority to sign amendment, effectively signed amendment, because there's going to be lots of them, including, for example, when you go off and order a bartender, and then you count the drink chits that got cashed in at that bartender. Technically, that's a contract. You're not going to require the chairman to come over and count drink chits.
I was going to say, again, chairman can delegate, and so they're effectively working as chairman for that particular scope where you've delegated. I was going to say that I've dealt with convention centers a few times. Yes, they have their boilerplate. They will sometimes do addendums that clarify the boilerplate or address issues not in the boilerplate that you have particular concerns with. We did that for NASFIC in Phoenix. We had a lot of clarifications and elaborations. Winnipeg, we had substantial amount of clarifications that saved us a fair amount of bucks. So they will stand the boilerplate, but they will elaborate.
Sort of related to that, and again, this is in the issue spotting area. If you're dealing with convention centers or depending on your jurisdiction, if it's just or their municipal employees, you may be dealing with unions. You probably want to know going in, is this a union facility or not? Particularly because we use volunteers, and there may be areas where, yeah, you're going to need to talk to the shop steward to say, hey, you know, we're a volunteer organization. I need to work with you. How can we deploy our volunteers in the context of putting this thing together? Because, yeah, you do not want to mess with the Teamsters.
All right, I see that Martin Easterbrook is streaming, watching us. He's asked the question, what about contracts or activities that expose you to facility risk? As an example, he said, like a fireworks display. I'm sorry, Bill Parker's not in here because we did do indoor fireworks in '97 at the Worldcon in San Antonio. But yeah, it's not as simple as sign the contract with the fireworks guy. You then got to see, is the facility going to permit it? Is there permission needed through local ordinance? Do you need the fire marshal to come in and say this? Okay, there's a whole lot of extra hoops you're going to have to jump through if you sign a contract that involves some risk, rather than just them showing up on the day and having them go, oh, well, we thought you got the permits. So yeah, any kind of a risk is, and then I think your lawyers may want insurance. The facility may want insurance. The facility may have mandatory insurance. Does that somewhat answer your question, Martin? Or do you want to make a comment? We're looking at the screen, so if you type in, we can see. While you were thinking about that, before we drift too far, we were talking about delegation on contracts. Z-Bang and John are sitting out there, and tech. How often do you run into tech where, because the contract's so large, the chair has to sign off on it, and how many times do you get that delegated? Thank you for stepping up.
There are small enough contracts that can be delegated? No.
No. Sometimes the tech budget is so huge that you can have contracts that.
In the Worldcon context, many of the contracts, yes, are high 5 or 6 figures with vendors, and those go right up all the way, including all of the boilerplate from those vendors. Some of the small ones, my practice has usually been, if it's a contract thing, if it's not me paying with it on my MasterCard and expensing it, I'm sending it over to the finance people to make sure it's complete. All of that stuff. Apropos of a previous comment, since I'm also a pyrotechnician.
Okay, please contribute.
Most of the company contracts are very clear, and it's actually interesting to read them. They're very clear on who gets the permits, who provides the guards, who provides this, who does that, what does the display company provide. They're actually very clear about that.
Okay.
And I actually encourage people to read contracts, because you find these things where you read through it and you say, didn't something happen at MumbleCon about 20 years ago? Would that have fit in?
Okay. Very good. Well, it may be an instance where one can always beware of boilerplate because of the specificity of the risk. The boilerplate where they're already covering a whole lot of stuff may be to one's benefit, rather than having the committee lawyer who looks at contracts try to handle something out of whole cloth. So, all right.
I wanted to throw in another war story that has to do with the specific bit that was brought up about unions. A couple of Worldcons, it was the Decorator Liaison, where it was union environment. And of course, we negotiated all the rules around which the union would operate in a fair amount of detail, got the company to agree to it, because we don't have a relationship with the union. The company has a relationship with the union. We're hiring them, who are in turn hiring legal people, union people to do the work. We made sure to involve union people in our discussions as well. And when you arrive at the convention, be prepared that any contract you have doesn't mean a whole lot to the shop steward or others who are on site. They will rewrite your contract, and good luck dealing with them. You'll spend a lot of time working out the issues. So just be aware that it's a special animal. You need to plan a lot around who will deal with the unions, establish a working relationship with them, et cetera. Because after all, if they say they aren't going to do it, you really don't have a recourse other than negotiating it out with them. The contract can't be stood on, because that comes after the convention's all done.
All right, I'm looking on here, and there's enough questions that were put to the panel that I don't know that we're going to get through in 1 hour. So before we go much deeper, since privacy law, all right, John, you got a question? No, yeah, let's stay on. Go, please.
So for people at home, John, Australian, non-US. So 2 things. One, I'll come back to in a sec. Bruce's comments are true, and it was a bit of a shock to me the first time somebody used the term the decorator, and I had no idea what that meant. And I subsequently learned what that means is a big black hole and smoke coming out and explosions and $100 bills changing hands so that you can get something moved. Culturally, I had absolutely no idea what that meant. But the caution I'd make is that culturally, most of the people in this room don't have any idea what it's like not being here. So we don't have the same situation with unions. It's businesses conducted completely differently in the Antipodes, and contracts will also be treated completely differently. There is no concept of an entity called the decorator, and certainly the people that you employ to do a job that the decorator might do operate in a completely different way to the way they do here, and relationships are completely different on that basis. So I guess the key message is, don't assume that because of the knowledge that you have that might be built up over many, many, many conventions is true for where you are. It's true for everywhere. It isn't. The other thing was the conversation that Bruce and I were having last night at the table, discussing tech finance and tech budgeting, which is really interesting. And Bruce and I very quickly agreed that for conventions now, tech is the number attributed to tech and sitting in the domain that tech would have to represent and spend is becoming increasingly large, but it's also one of the squishiest numbers that you have to deal with, that it can change very quickly, requirements can change very quickly, and the way it gets spent can change very quickly, and becomes the word we both used was amorphous, difficult to define sometimes what that budget is, and therefore what contractually goes behind that to ensure that you don't get into trouble.
Is that a case where you get the overall contract and then you move the pieces around and it's amorphous when you're settling on something final through amendment, or is it a whole lot of that done before you finally nail the final contract?
You would probably write it to be as amorphous as possible to give you the maximum amount of flexibility as possible, because what I would always try to be doing is coming up with a contract that allows me as the customer and the tech supplier as the supplier to do things on the fly that makes sense for the event, because unconditionally I can say that both tech people at a convention and the supplier will be committed to doing the best possible job so that nobody notices things going wrong.
Okay. Ben?
One general comment, John mentioned that contracts and other requirements differ from country to country. There is a giant divide in contracts. Almost all conventions so far have been on the same side of the divide. General legal concepts differ dramatically between US, UK, and the Antipodes, places like that, and continental Europe. They just have a very different legal concept. Fortunately, we've only had a limited number of World Cons that aren't based on the standard British-derived legal system. But if you're dealing in a civil law country such as Helsinki or Germany or things like that, boy, are things different.
Yes,
Okay.
virtually none of what we're talking about will apply in France with the Napoleonic Code-derived laws,
Or Louisiana?
unless you're in Louisiana.
Yes.
As I said, I don't do transactional law, but I mean, the court systems operate very differently. In a civil code system, you will have judges where they are judges, but they are also effectively acting as investigators. That's a very different context. Because it's civil code, if something had to go to court, for instance, in the US, typically there is a body of common law, decisions made by the court. There's been an effort to unify things with sort of uniform commercial codes, things like that in the US to try to, I think, make things look a little more like a civil code country. We're getting a little than we need to here. But it's a very different context on what counts as the precedent and things like that.
Okay.
If I can speak to that note, I am not a lawyer. Much of meeting law, hotel industry law, convention center law, things like that, at least in the US, is set by precedent. There's almost no underlying legal code that says what contract elements mean and things like that, which is why you actually need not a lawyer, but you need one of the half dozen firms that specializes in meeting law. So most of it in the US is done by precedent, and you cite these well-known cases. If you're in a civil law jurisdiction, precedent doesn't matter. What matters is written in the law.
It's what's codified. Civil law, they try to codify everything, where common law will have principles. We're halfway through and we haven't even touched on privacy. So we're going to move along to privacy. Ian, I know the GPDR, which is it 2 years old? Year and a half? Anyway, came in and obviously had a big effect on how you did things in Dublin. So go.
Okay, so I was the code, well, I had various jobs. In the end, I was co-division head for Dublin program. Early on, when we were just ramping up planning for program, the GDPR was in the process of going live. GDPR is the General Data Protection Regulation. It's an EU law, and we were we're part of the EU, so it was obviously going to affect us. Program holds a lot of personal data, so we needed to understand how we what that actually meant in terms of things we had to do. I should say that the convention retained an outside consultant through the finance division, and Bruce can probably say a little more about that. But in our plant, the way we handled it was to try, to sort of try and figure out what the principles were, try to do the right thing, run it by our outside consultant working through the finance division, and then like tweak things up and make sure we were actually telling the membership, what we needed to tell them, and also working internally to make sure we had processes to make sure we actually didn't screw anything up. One of the ways I think of dealing with legal issues in the context of convention running is that while they might be a pain at times, they are actually often helping you to do what you should be doing already and providing you kind of a framework in which you should do that. So how did that apply to Dublin? One important thing was how we could contact people, because we need, contact information and email address is personal information, and we couldn't just get an email address from some random source and then use it, because we would be, unless we knew the provenance and so on. So we got from some other convention, we didn't have permission to share the email address with us. It was at least questionable as to whether we'd be allowed to do outreach on that basis. If we actually knew people and had their email address, and then no problem. So we had to set up a set of policies for ourselves and our staff as to how we were going to do outreach. We required that all prospective program participants fill in a form. This may or may not have been strictly what we had to do under GDPR, but what it allowed us to do is make sure we didn't screw up handling people's data. A contact was initiated, it went through this form, it went into the Grenadine programming system, which some of you have used and more of you have heard of. And so that allowed us to actually have essentially an audit trail as to where the personal information came from and how, and to be able to track how we were using it. We had to have permission to store data. And a lot of you, probably almost everybody has seen this with notices from companies that started around May of 2018.
2018.
2018, with being asked to opt into to explicitly opt into certain whatever the terms and conditions they were being presented. So so we had to get the explicit permission. There are a few. I hope it wasn't anything I said. Is this okay now?
Yeah, it's nothing you're doing.
All right.
Speak up so we know it is. Get into the microphone.
Okay.
Move the microphone towards you.
Okay, so where was I? So we had to get the explicit information, at the explicit permission to store. There are different types of personal data under the GDPR, and there's a category called sensitive data, which we happen to be collecting some of that, and so we needed separate permission to store that data, and we separated that out because it wasn't mandatory. It was something we would want to have. We had to make sure we would be able to, if a request came to us, delete all of the data. Because if we get a request, and this is actually still true, the organization still exists, we still have all that data. If someone contacts the convention and says, you're holding my data, I don't want you to do that anymore, we have to be able to get rid of it. And so we had to develop our processes. And then we actually have a sunset, and we're going to destroy all the data at some point.
Is that, let me just interject, is that a policy decision that Dublin made, or is that a GDPR requirement that at some point after a once-off event you do that?
I believe it's GDPR. It certainly was something something that we were strongly encouraged to do by the consultant, as in told to do. But I suspect it was actually a legal requirement.
Let me let Z-Bang question or comment.
Just deleting data, holding sensitive data and then deleting it is good systems have backups of their data. And are you required to go through all of your backups and basically reback them up? Or how does that work under GDPR?
So my understanding is that we're not required to go through the backups and expunge all the data from the backups, but that from the interfaces that we're presenting to the users of the convention, that the data needs to be deleted.
Okay, some people in the room may not be able to read it. Let me see if I can read it. As Margarita said, that there are no specific durations. Article 5E of the GDPR states, personal data that shall be kept for no longer than is necessary for the purposes for which it is being processed. Yes. There are some circumstances where personal data may be stored for longer periods, e.g. involving purposes of public interest, scientific or historical research purposes. Thank you, Marguerite.
Yeah, so that would be the basis of having a cutoff where we delete it, because the convention's over. We in fact will not need the data once we have no more reason to communicate with participants. Therefore, we shouldn't hold it anymore.
And has that date been decided when you're sunsetting it and deleting it?
It has been decided. I forget what exactly it was. It's within the next year, I think.
Okay. Sean, I saw this came up when somebody made a comment about the online a few days ago about the code of conduct here. There was a clause in there, appeared that someone, if something of a criminal nature happened, that if they reported it to the code of conduct committee, that was, if it was something of a criminal nature, then they were going to have to then report it to the law enforcement. And this person wanted to say, wait a minute, I might want to report some degree of harassment. And if it even is, it is criminal for my own personal reasons, I may not want to elevate it to a law enforcement level. I know there's, depending on the state, there's going to be some people that are mandatory reporters. And so perhaps they should be on the conduct committee, because then they might be forced to report it, or even lawyers, depending on the state. As officers of the court, and there could be something that could come up that we would be ethically bound to report. So maybe we should be left off the committees, but you check by state. But what's your feelings on that?
You just want me to offend somebody, don't you?
No, I don't, but
Use the mic.
just pick it right up. Listen, it's just, there you go.
Well, before I answer, just brief segue. California adopted a Consumer Privacy Protection Act that goes into effect next year and mirrors a lot of the GDPR requirements. I'm not going to do karaoke. I'm not a mandatory reporter. I'm government prosecutor and I don't have to report. So if anyone wants to shoot somebody, I'm under no obligation to turn you in. I think the laws on who's a mandatory reporter vary from state to state. I don't know what would trigger them by professions, teachers, social workers, things like that. There is a specific requirement for counselors, therapists, if they learn something in the course of treatment, but that's more of an exemption to confidentiality than a mandatory obligation to report. With respect to, I don't know what with respect to codes of conduct have to do with this panel directly, but
Well, privacy, if somebody's going to be forced to report something to law enforcement because of the way the code of conduct is written,
well,
and they don't want that. I mean, I could suppose as a rule of thumb, I could go, well, if something came up, if it was a felony and I'd have to report
there's
it.
a difference between the convention's data collection for membership and information it learns through a report by an attendee or at least with respect to the United States generally. I would say that if there's a crime or a tort, you don't have any privacy because all of that is going to get exposed. A good case in point is a convention getting sued and all of the convention's email getting turned over to the other side because, well, of course, it's going to be produced through documentation. So don't write stuff down.
Well, no, I mean, it sounds a little flip, but yeah, when discovery comes around, you're in the lawsuit and your lawyer tells you got to hand over a bunch of emails.
Yeah,
they
so
wish you'd had
careful.
personal conversations on some subject.
Be careful what you put into writing. So I would say that with respect to codes of conduct issues, you should not assume that there's any privacy there, any that you can guarantee if it's going to go beyond the convention committee. Beyond that, I don't know what you want.
No, that's that issue. I just want to throw that up to you. Deal with criminal prosecution, and if that something of a criminal nature is likely what's going to trigger that from a code of conduct violation. Somebody's probably not coming in saying that dealer bilked me out of $100 on that collectible book, and you do something about it.
Some convention center contracts require you to have police officers there. This goes back to an earlier point regarding the contract. C-Bank said, read the contract. That's probably the best takeaway from this whole panel. Read the contract. Nobody does that, or very few people do that, it seems. Contracts often contain references to other documents. Those are part of your contract because they're incorporated, and you should read those. And
and understand, because that's one of the lines is often people saw it's the usual contract and sign it. They're not paying attention to particular provisions or related documents that tie into it. We sort of left off privacy there. So is there any further comments you'd make about how that was impacting Dublin? And do you see impacts on U.S. conventions? I know the GDPR, a whole lot of outfits in the United States went along with it just because they've got customers abroad. So I'm just going to use that as my one policy. All right, let me go Ian, and then Cathy, then Bruce.
Yeah, so one of the takeaways is that it was a positive exercise for us in that it forced us to think about what data we were taking and why we were taking it. And so after some rigorous review, because we did get a little bit of pushback on some of the data we were holding, we still continued to acquire it. It was a pain in some ways because we didn't put anyone program unless they asked to be on program by filling in a form. And participants who thought were just used to being asked, or were used to people who used to just be able to send an email, did not get on program. So there was a sort of a hassle there. I don't think that was a bad thing in the end. It's a question of training the community to work in the world we live in now. There's a question in my mind about GDPR, and it could be that Cathy or Bruce will be able to address this, which is for US conventions holding the data of EU citizens. Is there in fact going to be some changes in process that they have to deal with?
I think ultimately there may actually have to be, because as I read the GDPR, because you are providing goods and services to EU citizens, yes, it would apply even though we're in the US. Now, to a certain degree, some data can be limited in that we may not, as a convention, have a lot of financial information of the person if we're going through companies, third-party companies like Square or PayPal. It may be Square or PayPal that has the credit card numbers, etc. Honestly, we should be being careful with that information anyway, because virtually every state has cybersecurity laws. They have a privacy law. They have laws relating to financial information. You needed to be careful with that anyway. GDPR also, a citizen can request that you tell them what data you have and how you were using it. So these are actually useful worksheets that you can work out for yourself too, in terms of saying, well, okay, what do I actually need to do the functions that I'm collecting the data for? How much data do I have? Do I have too much? Because yes, you are going to probably need mailing addresses and email addresses in the context of administering the Hugos, site selection, pushing out progress reports, sending the program books to the people who are only supporting members, things like that. You probably don't need to hold it past 2 years, depending on what the Hugo voting rules are on who can nominate when. In that context, there may, for instance, be people who say, don't release my data to other entities, at which point you can push back. I used to do this in the context of certain things at the Postal Service, where people were trying to prevent junk mail, and so they would get these orders and your administrative law judge issued the stupid thing, and our response was, well, our judgment stands, but you can tell the customer you're not closing their bank account. So you can actually push back on people and say, well, look, we can do what you asked, but understand then that in this context, the next WorldCon may not be able to reach out to you to put you on program. You will probably not receive the notifications you need. We will not be able to certify, the next WorldCon will not be able to certify that you are eligible to nominate for the Hugos. Do you want to lose those things, or do you want us to turn over the data? GDPR is the one with the biggest reach. In a lot of countries, it requires that the corporate entity have a physical presence. So for instance, when I went to the PLI course on privacy law, they do this sort of 2-day survey course and then a 1-day, state of the law one at the end of the year, which I will be going to next week. I was kind of in a panic because they kind of crashed through China, which has some fairly onerous laws with some major consequences, and ended up on the lunch break going to the person and saying, well, look, if here's what WorldCon is, in 21, we would expect to have a lot of Chinese members because of the site selection vote. Are we going to have a problem? And the answer was no, not unless you open an office in China. Similarly, a number of the Canadian laws only apply if you actually have an office in Canada. With the California Consumer Privacy Act, while it's a bit of a mess because of the nature of how it got passed, where the legislature set a land speed record to prevent something going to a ballot initiative, because ballot initiatives can only be changed by other ballot initiatives, and no one wanted that. The minimum requirements for the law to kick in involve companies with revenue of 25 million, or you're holding data on 50,000 people, how devices, or 50% of your revenue derives from selling personal information. I don't think most WorldCons hit those markers. But most states are now in the process of, if they don't already have such laws, crafting those laws. In addition to that type of issue, states also have cybersecurity laws. So we need to think about how we're protecting the data while we're holding it. And so I do think, and also a number of Latin American countries are also in the process of passing GDPR equivalents. So these are things you need to think about. Similarly, this is kind of a wonky US thing. It's less of an issue than it used to be because of things like PayPal, where you can have people go by PayPal to make payments on your website, and you can push people towards joining electronically. But I know, and this is really more of a WorldCon context than a tiny local context, where the issue there would be know your state, county, and municipal regulations. It used to be that people would have, like, you know, and say a English agent or a European agent or a Japanese agent who might be using their personal account to funnel checks from you know, members from those countries and then sending it to the US. I am blanking on the name of the tax law. I am not a tax lawyer, but in that context, there is a law on the books that would require the person to then file really onerous financial documents with the IRS. So, you know, at this point, don't have a foreign agent, you're kind of screwing them. That would be my take on it. Don't do that. Or at least don't have them sort of do financial transactions for you in that context where it's running through their bank account. Do not do that. And so I think in general, even if GDPR weren't there, we probably wanted to start thinking about how we were holding the data anyway. It's coming up in a US context as well. There's cybersecurity issues. A lot of the time you're insulated if you just have a plan. You know, you explain that you have the plan, third parties, et cetera, may actually be the ones holding the liability if you're not holding the data.
Right, Sean, you had something else you were gonna.
Well, she covered some of it, but with respect to privacy laws in other jurisdictions such as Europe, the safer practice is probably to assume that they apply to you, whether or not they actually do. And I don't think it's automatically true that it would apply to a US-based convention. But again, safer practice, assume that they do. California, the reach of the Privacy Act is still pretty broad. WorldCon might not necessarily qualify, but there's an avenue for it to. Also, California has an enshrined right of privacy in its state constitution. It's one of the very few states to actually do that. It's kind of funny to think that our right to privacy grew out of contraception cases, but that's where it comes from. And this is probably only the beginning, so, you know, be careful what you do with stuff.
Okay, Bruce?
I was just going to say, on the practical side of things, just as an example, my wife ran registration for Dublin and has the membership database. She will not share the database with me, no matter how much I beg and plead if I need particular information. So that's one practical aspect, is indeed limiting the information. We do pass on the information for the use for Hugo's. After we do pass that information on, it's very likely we'll delete our files. So there's limited lifetime for that data. Prior to that, I used to actually keep a database, which was very, very, very limited use of past WorldCon info, because program and others would need info. That's not going to be done anymore. But that was a use we used to have for databases, is very restricted use and high security on it, so we could contact people we need to contact for valid business reasons. So again, the overall rule we have is we keep the data protected. We don't disclose it. We only have it for valid business reasons and only use it for valid business reasons. And we do third-party contacts for a person wanting to contact someone. We don't ever disclose personal data to someone else, but we'll sometimes act as a clearinghouse. That is, us contact the other person. Say Joe Blow wants to find someone. We'll send on the contact info and they can do whatever they wish to. So we act as a kind of a filter if there was a valid business reason for them to have contacted us to begin with. So we try to abide by all the GDPR rules in the U.S. conventions too, like San Jose. I know we did to a large extent too.
Z?
Sorry, me again. This is one place a lot of conventions fall over, is they don't explain, they may explain, okay, we're keeping this, but they don't explain why they need the data and how they will use it. We use this to send you progress reports. We use this to validate your membership. We use this to send you this. We do not use it for any other thing. And some have not even gone through the thought exercise of figuring out, why do they need someone's postal address? Oh, so we can send you progress reports in the mail, write it down, put it in your thing. The other part is a lot of WorldCons now are going to using G Suite for their internal communications and so on. A lot of misunderstanding between regular Google accounts and G Suite educational accounts, which follow a whole different set of privacy rules than your personal Gmail account does. And Andy Trimbley can explain this at length if you ask him. Okay. But some WorldCons have not done a good job of explaining how it's different and why they use it and how it will be different in the future.
Ian, a couple things you said triggered some questions for me. You said you got some pushback on some of the data you wanted to get from program participants. What were they pushing back on?
That was primarily demographic data, because we're working very hard to develop a program which was balanced and diverse across multiple factors.
Okay.
And if you don't actually know what have any of that information, you can't do that.
Okay, and once you explained that, did you still get pushback, or did the mostly people say, "Oh, okay"?
There was grumbling, but no more pushback.
Okay.
And what the consultant really was looking for was that, and this kind of echoes a little bit about what Zbang said, is the consultant wanted to make sure we really had a reason that we could write down and justify for holding that data. So, I mean, I think one way to think about GDPR and another that type of regulation is that it's implementing certain principles. And if you understand the principles, not just exactly what it's trying to tell you to do, but why, it's going to help you craft a solution, right? I mean, for example, in our forms and the program forms, we actually explained why we were holding the data. And that was something the consultant wanted us to do. It made total sense. And then users, I mean, the participants could say, no, I don't want you to hold that sensitive data, and then click the box, and then we didn't, and then we didn't. The odd thing was some people supplied it after checking the box saying couldn't hold it. But that we still didn't hold it because we didn't have their permission.
Okay, and then you said you couldn't approach people, they had to approach you. Presuming a legitimate, permittable contact, did you ask someone to ask you, hey, could you ask us to be on program?
Right. So there were several things we did. If someone expressed an interest, like in person or over email, to be on our program, we said, "Thank you. That's awesome. Here's the link to the form. Go fill it in." If we knew someone was a friend of someone who really ought to be contacting us, we worked those channels. Said, so and so hasn't expressed any interest in program. They might think they're going to contact us. We're going to contact them. We're not. Can you tell them that and tell them that they should contact us if they're interested? And there's probably a few other things we did along those lines, but if we knew somebody, so it was a friend or acquaintance of ours that we had we just already had their contact information because one of us personally knew them, then we contacted some of those people and said, hey, you might be interested in being on program. If you are, go fill in this form.
Okay, kids, they didn't give us the morning, but it is 5 to 12, and I know two of my fellow panelists and someone in the audience have noon appointments, and somebody I can see in the hallway has a noon appointment. So we're going to wrap it there. Thank you very much for attending.